MSW Media.
So yeah, now it's clean up on aisle 45 time. And for a long while yet, it is going to be clean up on aisle 45.
Hey, everybody. Welcome to episode 232 of Clean Up on Aisle 45. We've been doing this for 232 weeks. It's Wednesday, July 2nd, 2025. I'm Allison Gill.
Hey, G, what's up? It's Harry Dunn here. We got a lot to talk about today, including a jury ordering an insurrectionist to pay $500,000 for assaulting a police officer who died by suicide after the attack on the Capitol, and a federal judge denying a motion from a Capitol rioter who wants his restitution back.
Yeah, he's not going to get that. Same as with the other one, right? The Treasury has the money and you can't just get it back. We also have a story about the DOJ coordinating with Texas Attorney General Ken Paxton to kill the Texas DREAM Act. And that was that 6-hour case that we talked about a little bit on the Daily Beans, where I was like, this had to have been coordinated.
Yeah.
It was. Also, Gavin Newsom is suing the Fox News Corp for $787 million for defamation.
I wonder why that number.
Yeah, it's an interesting choice of money. And we have updates on the cheese, Ken Chesebro. And of course, Rudy Giuliani we have a story about him and Lewandowski. But first, we want to thank our new patrons. So thank you to Marie Russo, Descendo Decimus. I hope I'm saying that properly. Sharks with an E. As Zan Jones, Double Deuce, Lori Thistledown, let's see, Macau, Rizas, and A. Corwith. If I pronounced any of those wrong, you just let me know, and you can be rude about it. It's totally fine. Thanks for being patrons. You make this whole entire show possible. If you want to become a patron and join our little family, you can do that at patreon.com/aisle45pod, AISLE45POD. And among the logjam of terrible Supreme Court rulings, the parade of horribles that came down last Friday, one did not, notably. And instead, they ordered further arguments. And this was over Louisiana's congressional map that was approved by the state's GOP-led legislature. And it created a second majority black district. Now, joining us today to talk about this case and where it is now and where it might go is National Voting Rights Correspondent for Mother Jones and author of the book Minority Rule, The Right-Wing Attack on the Will of the People and the Fight to Resist It. Please welcome Ari Berman. Hi, Ari.
Hey,
Ari,
guys.
Welcome to the pod, my friend.
Good to talk to you again. Thank you.
It is so great to talk to you. So if you could give a little brief background, this has been winding its way through the courts for a while, on what's going on in the Louisiana redistricting case, that would be great.
So it was very, very strange because last Friday, which was supposed to be the last day of the Supreme Court's term, we were refreshing. It had been an hour and a half, and we were waiting for the last opinion. The last opinion was supposed to be this Louisiana redistricting case. And the Supreme Court just said, actually, we're done. Case is not going to be decided. And me and all the other people following it were like, what's going on? And they decided to re-argue the case next term, which is very, very strange because this case shouldn't have been that complicated. You had both Louisiana and civil rights groups like the NAACP Legal Defense Fund arguing on the same side, which in and of itself was very unusual, basically saying that Louisiana, under the Voting Rights Act and the Supreme Court's recent precedent, was correct to create a second majority black district because the Supreme Court 2 years ago in a case from Alabama said exactly that. They said that Alabama had the opportunity under the Voting Rights Act to draw a second majority black district, and they should do so. And Louisiana's case followed quite similarly what Alabama did. So we thought this was going to be the same outcome as what happened in Alabama, which would be a rare occurrence where the Supreme Court did something good on voting rights. But it seems like the Supreme Court took a case where they should have done something good on voting rights and now seem to be setting the stage to do something very bad on voting rights. At least that's what the speculation is right now.
What is the Supreme Court even doing if both sides are in agreement? Is this like another we need to make a rule for the ages thing? Like I don't even see dicta. Like why does the Supreme Court even have this if everybody's kind of in agreement?
The worry here is that the Supreme Court's setting up to do something very bad to the Voting Rights Act and basically saying that the Voting Rights Act can't be used to strike down racial gerrymandering, which would be at odds of 60 years of precedent with the Voting Rights Act. But in that Alabama case I mentioned, Brett Kavanaugh signed on to the majority opinion in that case that was written by Chief Justice John Roberts, who is himself someone that has repeatedly weakened the Voting Rights Act. We're not exactly dealing with like a glass half full situation right here to begin with. But Kavanaugh in that opinion in Alabama basically said there may be a time when we don't need the Voting Rights Act's protection anymore. He said, I'm not going to decide it in this case, but I might revisit it in the future, which sort of was like a flashing red light right there that something bad was going to happen. This was not an issue in the Louisiana case, but the worry here is that Kavanaugh and the other conservatives on the court want this question teed up. They want Louisiana to address this more specifically, and they want to use this case, which should be relatively straightforward, ruling for minority plaintiffs, instead to become another vehicle where they roll back the Voting Rights Act, which they've already done on repeated occasions, to the point where basically the Voting Rights Act, which is already severely weakened, essentially loses all its teeth altogether.
Well, something that you mentioned, and you're talking about the dissents or whatever, Clarence Thomas is in his dissent talked about he wants to impose limits on race-based redistricting. It's kind of ironic that one of the Black judges on there wants to put limits on the race-based redistricting. Isn't that what this is all about, though? The minority people are getting fair representation. Isn't that what this case, the heart of it is?
Yeah, basically. I mean, and Thomas has been arguing this for basically 30 years. He doesn't believe that the Voting Rights Act should be used essentially to strike down racial discrimination when it comes to redistricting maps, which would lead to a huge loss of representation in a lot of different places, particularly in the South. It's interesting he dissented because it seems like the court is moving closer to where he's at in rehearing the case, but he just wanted them to do it all at once, which the justices evidently were not prepared to do. But basically, yes, you're right, Harry. This would essentially roll back, if they were to rule in such a way that gutted the Voting Rights Act again. This would be something that would lead to a loss of minority representation in the South. The reason this case is before the Supreme Court now is because there's been an underrepresentation of Black representation in the South, in places like Alabama and places like Louisiana, where you had basically there was one Black district in states where a third of the population or more were Black. And so civil rights groups argued that there should be more than one district. The Supreme Court agreed with that in Alabama. They seem set to agree with it in Louisiana. Now they seem to be sort of hitting pause on that and potentially preparing to do something that's much more sweeping in the opposite direction.
Ari, what's even left of the Voting Rights Act? Because we know they got rid of the pre-clearance requirement, which was where any southern states with the bad habits in the past had to get pre-clearance from the Department of Justice if they wanted to change their voting rules. We know they really limited or narrowed or pretty much gutted racial gerrymandering by saying it has to be explicitly racial, right? Like in order for it to be considered that. What's left of are they going to just take that bar away completely? What's left to gut from the Voting Rights Act?
Yeah, this is really one of the only thing that's left to begin with, which is why people are so concerned about this Louisiana case, because they've basically made it so that states with a long history of discrimination no longer have to approve their voting changes with the federal government. They've made it so that when states pass new restrictions on voting, they're very, very difficult to strike those down under how the Supreme Court has ruled. They've made it so that you can't strike down partisan gerrymandering. So if a state basically just says, yeah, I wrote a totally unfair map, but I just did it for partisan reasons, they've said that's okay, which is totally
so it was for
odds.
The partisan gerrymandering, but not for racial gerrymandering. Exactly. And now they want to get rid of that.
Racial gerrymandering is really one of the only parts of the Voting Rights Act that still has teeth. Now, you're right, they have narrowed it in a number of different contexts, but still recently in the Alabama case from 2023, when they said that under the Voting Rights Act, Alabama had to draw a second majority Black district, that was a good move for voting rights that was at odds with all the other opinions by the court when it came to this issue. And that's why it was sort of shocking. It was shocking to see it written by Chief Justice John Roberts, who wrote that 2013 opinion gutting the Voting Rights Act. It was even more shocking to see Brett Kavanaugh sign on to it. And now I think some of those people may be having second thoughts. And again, the problem here is that to get to 5, right, You have to have 2 of the 6 conservatives sign on to something, which just means that there's so little room for any kind of common sense to prevail here, that these are people who are put on the court because they oppose things in the past, like the Voting Rights Act. So counting them to do the right thing in this context is a very, very hard and a very, very precarious position for vulnerable and historically disenfranchised communities to be in.
Well, yeah, Allison talked about earlier, is this the setup for them to drop a bombshell in the coming up? But I also want to talk about, or just bring up, I had the opportunity to go out to Oklahoma earlier in the year, and just seeing the districts out there and how they were gerrymandered. And I wasn't truly familiar with the term racially gerrymandered. But it makes a little more sense. You know, you have Oklahoma City and Tulsa, which are urban areas. And the closest district is to a Democratic representation is Republican +9. And that's Stephanie Bice out there. Does this set up going forward for other states like Oklahoma? Because, you know, just talking on the ground with some of the elected officials out there locally, they're hoping that, you know, what happens in Louisiana and what happened in Alabama, they have teeth, like you said earlier, and they can stand on it out in Oklahoma. So is the fate of the rest of the nation looking at, are all eyes on Louisiana right now? Is that kind of what this is?
It is, just because, I mean, this is one of the only examples of the Supreme Court potentially doing something good when it comes to policing racial gerrymandering. They've already said on partisan gerrymandering, they're not going to do anything. So this is one of the only ways to rectify an unfair redistricting map, would be to say this was racially discriminatory. And so if they said it in Alabama, if they said it in Louisiana, that would be something of a trend, right? And you could potentially say, okay, maybe this is one area for whatever reason, the Supreme Court's more sympathetic to voting rights. That said, if they close the door on that completely, it'll basically be impossible to strike down maps that are discriminatory in a partisan way or in a racial way. And it will give those in power just an incredible green light to discriminate against people. And I think that's really disturbing. And I think I'm particularly disturbed that this is happening at a time when the Voting Rights Act turns 60 this year. And there seems to be no recognition from the majority on the court of the historic nature of this law, of what it rectified, that it quite literally ended Jim Crow in the South, that the Voting Rights Act was, more than any other piece of legislation, what finally struck down those barriers that people had to being able to change their own circumstances, change their own lives. And I just think that the retreat from this, it's not just one case, it's a 60-year retreat from enforcing the country's most important voting rights law and the most important civil rights law. And to me, that's the most disturbing larger project that they're doing. Not to mention they're giving another political win, another political battle, another political gift to the Republican Party, even though in this case, the Republican Party is actually saying, we want to keep this district. Yeah. And I think in the long run, places like Louisiana would be much happier just to say, let's get rid of the Voting Rights Act.
Yeah, it's kind of ironic that, you know, the phrase, we won't go back, during the Harris campaign, it wasn't just talking about back to Donald Trump. It meant taking us back to civil rights, voting rights, being Jim Crow era. So, man, it's really frustrating to see what this is playing out.
Yeah, and Kavanaugh's, you know, little note in Alabama saying, I don't like this one to completely gut the Voting Rights Act, so I'll look for a new one. And then having this be put off until next term doesn't bode well. Before we let you go, when they say argue next term, but that something could come down from the court maybe tomorrow, Thursday, as you're listening to this episode, what are we looking at?
Well, they have to explain why they're re-arguing the case, meaning will there be new questions that are presented here? Because all of these cases have a question they're supposed to answer, right? And the questions
in this case, having a hard time formulating this one.
Yeah, the questions in this case were fairly narrow, and people thought this case was relatively straightforward. And so what we're waiting to see is, do they add a new question that gets to the constitutionality of the Voting Rights Act in such a way that they can expand this case to try to strike down the key remaining parts of the VRA. So that's what we're looking to. They said the order would come in due course. We have no idea what due course means. The justices have all dispersed to Malta, wherever they are, teaching fake classes for the summer. So, I mean, this is just another example of the Supreme Court not operating in a very transparent manner, where they postpone a case and then don't even explain why they're re-arguing it. And by the way, they're going to now re-argue it in an election year. So
that was my other,
It's going to imagine if Louisiana has to draw new maps in an election year. And yes, this is only one state. I mean, this case has ramifications well beyond Louisiana because it concerns the Voting Rights Act, and that concerns a lot of different places. But even this one seat, I mean, given how close the House is right now, every seat matters. I mean, we see President Trump is now leaning on Texas Republicans to redraw their districts in 2026 or 2025, which would be crazy to just all of a sudden do that. We have Ohio's going to draw a new map. I mean, people are thinking, I mean, who knows? It could be a wave. Republicans could lose 20, 30, 40 seats, or it could be very close. And the way the maps are drawn could make a huge difference. And I'll just give you one example. North Carolina redrew its districts after the North Carolina Supreme Court basically said Republicans were free to gerrymander.
Yeah.
Republicans in North Carolina picked up 3 seats, and those 3 seats are the majority in the House right now. That is the difference in the House right now. So all other factors aside, gerrymandering decided the House majority in 2024, and it could very well decide the House majority in 2026 again.
Yeah, well, we'll see how it shakes out. We appreciate you coming on, and look forward to maybe having you back to discuss the question when it arises. Because I thought the immunity case was straightforward. We're only supposed to be focused on the specific case before them, and then they rewrote the question in order to write a rule for the ages. And so I think maybe they're trying to formulate that question so they don't sound as racist as they are. But before
we let you get out of here, I'm going to ask you an impossible question. How do we, as a whole, how do you get rid of this? Is it even possible? What's the ideal solution to get rid of gerrymandering as it is? How?
What do we do?
I feel like but not even just that, but the politicians, the people, the ones that are crazy for the power. And I'm sure that will always exist. So can we really get rid of it? I don't know. Can we curtail it? Is it a way to get this? I don't know. What are your thoughts on that?
Well, the federal voting rights bill that Democrats almost passed in the last Congress would have banned partisan gerrymandering and also limited racial gerrymandering. And that would have been incredibly important because it's very hard to police this through the courts right now. And the courts are dominated by people who don't like the Voting Rights Act. And it's very hard to do this state by state by state because there's some states that'll be open to doing this in the state level, but other states won't. And so I think we're in a situation that's not unlike the situation we were in 1965 where the Voting Rights Act was passed, which is there was no substitute for congressional legislation back then. You were not going to ban poll taxes on a state by state basis. And you were not going to go into places like Louisiana and ban poll taxes through the Louisiana legislature or the Alabama legislature, right? Because those legislatures were dominated by Southern segregationists. So the same way, you're not going to be able to just go into gerrymandered states and ungerrymander them through the normal political channels that owe their power through gerrymandering. So I think this is the kind of place where federal legislation is incredibly important. It's unfortunate that it didn't happen a few years ago when there was a chance. That's particularly ironic given how Republicans are gutting the filibuster right now. To pass a absolutely terrible bill that is incredibly unpopular and that nobody wants. But I still think that we have to get back to talking about the need for a federal solution here, because there could be states that enact bans on gerrymandering, but I think it's going to be hard to do anything that has a nationwide impact absent the Congress doing it, the president signing it, and then the Supreme Court not striking it down.
Well, that's the Supreme Court would gut any new law, which is why I think the next Democratic president should just issue an executive order, and then there can't be a nationwide injunction against it without a class action lawsuit. Anyway,
so I'm basically another generation. I'm about to say, so another generation. So
let's hope it doesn't take that long. But I mean, I think in the back of people's minds, I think you make a good point, Harry, which is everyone's reacting to things Trump's doing right now. And that makes a lot of sense because there's so many things he's doing, him and his allies. Yeah. But I think we also have to think, what would a different situation look like, and start planning for that day whenever it might come.
Yeah,
Agreed.
I like that.
All right, man. Thank you so much for joining us, and tell everyone where they can find and follow your work, please.
You can follow me on Blue Sky at Ari Berman, and you can read my stuff at motherjones.com, and you can buy my book, Minority Rule, wherever books are sold.
Yeah, buy 10 copies. Put them in your little libraries around your neighborhood.
I'm getting one.
Do it. And like I tell everyone on whenever I talk to an author, I'm like, just buy, every time a cool book comes out, just buy a bunch of them and just keep them in your like holiday gift closet, and then just wrap them and just hand them out when you go to parties. Just instead of a bottle of wine, bring a book or both.
Or
yeah,
both.
Who doesn't
I was just
want to
say,
bring
or
a book
both
instead of wine to a party? I mean, that's just really that's just the best way to make an entrance.
Right? How cool are you? Booking a bottle of bourbon? You are the best.
You are. Absolutely.
The biggest gift would be from me, and the tag attached would say, thank you for being a friend. All right. It's been good to talk to you, my friend. We have a lot of news to cover for the rest of this show. We're going to be talking about one insurrectionist who has to pay a $500,000 award from a jury, and another who is not going to be able to get his money back after paying restitution and fines for his role in the insurrection. So everybody stick around. We'll be right back. Hey, everybody. Millions use CBD from CB Distillery for one simple reason. It works. Over 90% of customers report better sleep, and their clean, targeted formulas help with stress, pain, focus, and like so many things. They even have CBD for pets, which I love. And there's no fillers, no gimmicks, just premium, trusted relief for whatever life throws your way. And I want to thank CB Distillery for sponsoring this episode. Get 25% off your entire purchase at cbdistillery.com and use promo code CLEANUP. Now, I've tried a lot of CBD products over the years, but CB Distillery has become my go-to for reliable, targeted relief. Their sleep gummies, my favorite, bar none. I take one before bed, and within about 30 minutes, I feel relaxed and ready to drift off. No grogginess in the morning, just solid rest. On the flip side, their CBD Pain Stick is a lifesaver for sore muscles and sore joints after long days or tough workouts. It glides on easy, smells great, and it gets right to work. And what I really love is all of their products are made with clean, high-quality ingredients and zero fillers. With over 2 million happy customers and a 100% money-back guarantee, it's easy to see why people trust CB Distillery. So if you're dealing with stress, poor sleep, or pain, give it a try. You've got nothing to lose and a lot of relief to gain. And for a limited time, you can save 25% off your entire purchase. Visit cbdistillery.com and use promo code CLEANUP. That's all one word. cbdistillery.com and use promo code CLEANUP. One more time, cbdistillery.com. Specific product availability depends on individual state regulations.
All right, y'all. Welcome back. All right. So we have a couple of stories about insurrectionists losing money. Great way to continue. So from the Associated Press, a federal jury on Monday awarded $500,000 to the widow and estate of a police officer who killed himself 9 days after he helped defend the U.S. Capitol from a mob of rioters, including a man who scuffled with the officers during the attack.
The 8-member jury ordered that man, 69-year-old chiropractor David Walls Kaufman, remember this guy? He has to pay $380,000 in punitive damages, $60,000 in compensatory damages to Aaron Smith for assaulting her husband, Metropolitan Police Officer Jeffrey Smith, inside the Capitol on January 6th. They awarded an additional $60,000 to compensate Jeffrey Smith's estate for his pain and suffering.
Yeah, the judge presiding over the civil trial dismissed Aaron Smith's wrongful death claim against Walls Kaufman before jurors began deliberating last week. U.S. District Judge Anna Reyes said no reasonable juror could conclude that Walls Kaufman's actions were capable of causing a traumatic brain injury leading to Smith's death.
Okay, so that's why this is $500,000 and not $5 million.
Yeah.
Is because that wrongful death claim was dismissed from the suit. Now, Walls Kaufman, this insurrectionist who lived a few blocks from the Capitol, denied assaulting Smith at all. He says any injuries that the officer suffered occurred later in the day when another rioter threw a pole that struck Smith around or near his head. That's a hell of an argument.
Yeah, exactly.
Like,
But however, the jury sided with Aaron Smith last Friday and held Walls Kaufman liable for assaulting the 35-year-old husband, an encounter captured on the officer's body camera. So So much for that eye in the sky didn't lie right there. After the jury left the courtroom, Reyes encouraged the parties to confer and discuss a possible settlement to avoid the time and expense of an appeal for the sake of finality. You guys settle. You can move on with your lives, the judge said.
Yeah, and what he means by settle is, they were awarded $500,000, but now this guy can appeal and appeal and appeal and put this off for years. So he's encouraging the parties to come to an agreement, like just pay this now, and we'll keep you posted if there is that kind of a settlement.
Yeah, I'm talking to Erin. We're looking forward to getting her on the show. But this isn't about money, and there's nothing more final than death. She lost her husband. Yeah. So, I as much as I know Erin, I haven't asked her this specific question, but I know that she's not going to roll over and she's make this guy pay. And you know what? I support her wholeheartedly. And like I said, hopefully we'll get her on the show in the next couple of weeks.
Yeah, I'll be honest. If she says, yeah, I'll settle for $500,000,
exactly.
I would support that. But if she also went a little lower to not have to go through the mental health anguish of continuing on appeal and having this still hanging over, whatever she decides, I'm 100% behind her.
Absolutely.
All right. Next up, in a 9-page ruling issued by a federal district judge in the District of Columbia, Obama appointee Randolph Moss, wrote the following. He said, "This matter is before the court on defendant Hector Emmanuel Vargas Santos's motion for a refund of fines and restitution and return of property. The government does not oppose this motion." Oddly. Nonetheless, for the reasons explained, the court will deny the defendant's motion. The judge says that on January 6, 2021, Vargas participated in the riot at the United States Capitol. Vargas was one of thousands who descended upon the Capitol that day, but he was one of the first individuals to breach the restricted Capitol grounds. After remaining on those restricted grounds for several hours, Vargas forced his way into the Capitol building and rotunda with a crowd of rioters. Vargas and his fellow rioters caused substantial physical damage to the Capitol, requiring the expenditure of more than $2.8 million of repairs.
Yeah, before receiving his pardon, Vargas paid a total of $2,026 in restitution and fines. After the court dismissed the case, Vargas submitted a request to the finance office for a refund of his payments, but the office responded that it was unable to issue a refund. This led Vargas to file an instant motion for an order requiring a refund of his payments. The government filed a response stating that it agrees that Vargas's payments should be refunded.
Yeah, Trump's DOJ agrees with Vargas that this money should be given back to him. Now, Vargas and the government's principal contention is that the finance office was wrong to rely on a case called Note v. United States when it denied Vargas's request for a refund. That's the office, okay? Like the present case, Note v. United States arose from the issuance of a presidential pardon. The petitioner in Note, that's his name, by the way, Note, was a Confederate supporter. And following the Civil War, the United States confiscated and sold Note's property, quote, on the alleged ground of his treason and rebellion. The proceeds of that sale, totaling $11,000 at the time, or about $200,000 if adjusted to current purchasing power, were then, quote, paid into the Treasury. So they seized his property, sold it, and put it in the Treasury. After President Johnson granted a blanket pardon, quote, to all persons who had directly or indirectly participated in the rebellion, Note filed suit in the Court of Claims seeking the proceeds from the sale, but the court dismissed his case. The Supreme Court thus considered, quote, whether the general pardon and amnesty granted by President Johnson entitled pardoned individuals to the proceeds of their property previously condemned and sold, after such proceeds had been paid into the Treasury. The Supreme Court concluded, no, you can't have it back.
That's interesting. I wasn't aware that this was a already had precedent for this.
Yeah, and that it comes from the Civil War.
Absolutely. And, I am here for all of them losing. So, but notably, the statute at issue in the Note did not require a criminal conviction at all. And there is no indication that Note himself was ever convicted of treason. If individuals who were never convicted of a crime are not entitled to return of their property following a pardon, then it stands to reason that the same rule applies to individuals whose convictions were vacated, not because their convictions were invalid, but because they received presidential pardons. And like the petitioner in note, Vargas's payment have left the custody of the executive and judicial branches and have been deposited into the U.S. Treasury.
Yep. The court accordingly concludes that because Vargas's conviction was set aside by virtue of a pardon, and because the funds have been paid into the Treasury, note applies. So that case from the Civil War applies. And under note, the court must deny Vargas's motion.
And for those reasons explained above, Vargas's motions for refund of fines and restitution, all $2,000.26 of them, and return of property is denied.
I mean, he only had to pay $2,000 and whatever dollars and 19 cents or whatever. Is first of all egregious.
It's egregious. I'm about to say that's it.
All of the insurrectionists should have had to pay. If you were like, okay, we're going to have about 2,000 convictions and they owe about $2 million, so divide, and each person should pay this. $2.8 million, so $3 million divided by however many convictions we might see.
Yeah,
and even do a conservative. You're going to get a little bit more than $2,000. So
yep.
Note lost his $200,000 house. This guy lost $2,000 in fines, and Note wasn't even convicted of anything.
It wasn't even convicted. He was just a supporter, right? Supporter of the Confederacy.
Mm-hmm.
Yeah. So, well, don't storm the Capitol next time, I guess.
Oh my God! Right.
Simple, right?
Yeah, and I'm interested to see what if Trump's Department of Justice does about the fact that these funds are already in the Treasury. Are they going to release them? Are they going to put them in some, I wouldn't put it past this Department of Justice or this Treasury, right, to set aside a fund to repay restitution to the pardoned January 6th insurrectionists or some shit.
Yeah.
You know what I mean?
I wouldn't be surprised. You're right.
So look forward to the day we can be mad about that, because I feel like it's coming.
It's coming, right?
Yeah. All right. We have more to get to, including that 6-hour lawsuit. Remember when the DOJ sued Texas, and Texas was like, "Oh goodness, a lawsuit! Settle." And, and we were like, "Come on, they had to be talking to each other." Well, they were. So we're going to talk about that right after this quick break. Stick around. We'll be right back. All right, everybody, welcome back. Our next story comes from NBC. If you listen to the Daily Beans, we covered this story a while back. You'll remember the 6-hour lawsuit filed against Texas by Trump's Department of Justice to scrap a law that gave immigrants in-state tuition. And I said, this has to be coordinated. Well, it was. A top Justice Department official boasted at a private Republican gathering that the Trump administration was able to kill a Texas law that gave undocumented immigrants in-state tuition, quote, in 6 hours, by coordinating with the Texas Attorney General, Ken Paxton. That's according to a recording obtained by NBC. Lordy, there are tapes. On June 4th, the Justice Department sued Texas over the Texas DREAM Act, and then quickly filed a joint motion with Texas asking a judge to declare the law unconstitutional and permanently enjoin Texas from enforcing the law. All the parties were in agreement, and the same day, the judge did just that. Now, outside organizations sought to invalidate the ruling this past Tuesday, arguing that the Justice Department and Paxton's office, quote, colluded to secure an agreed injunction and engaged in improper legal choreography to obtain their desired outcome. Speaking at the Republican Attorney General's Association, a day after the quick court victory, Deputy Associate Attorney General Abhishek Cambly seemed to confirm just that. Quote, so yesterday, we filed a lawsuit against Texas, had a consent decree the same day, or consent judgment, and got it granted just hours later. That's what Cambly told participants, according to that tape obtained by NBC News. Quote, and what it did was, because we were able to have that line of communication and talk in advance, a statute that's been a problem for the state for 24 years, we got rid of it in 6 hours. That's what he said.
Cambly, who previously worked for Kansas Attorney General Chris Kobach, added that the Justice Department has good relationships with state attorney generals, which allows it to get things done, end quote. Cambly also said the second Trump administration is learning how to be offensive-minded, according to the audio. Quote, I think the biggest critique of the first time around in the Trump administration, there were a lot of missed opportunities to wield federal government power for the things that we value that just never happened, Cambly said. And he goes on, but this time we brought in a lot of new people from state AG world that have done that kind of litigation, know how to do it, and have been doing it.
What kind of litigation? You just made a deal.
Yikes. Wielding federal government power.
To overturn laws you don't like in red states by suing. This isn't going to be the first, or it's not going to be the last.
Not going to be the last, yeah.
It is the first. Paxton's office didn't respond to requests for comment. A Justice Department spokesman did not dispute that Cambly made the statements and said it was pretty standard for Justice Department lawyers to notify state attorneys general of federal lawsuits ahead of time. Yes, but it is not pretty standard for the Department of Justice to collude with state attorneys general to get rid of laws that you don't like on the books that were passed by the legislature. Now, he cited a Justice Department policy that provided fair warning for state attorneys general before filing lawsuits. That's not what this was. You were warning the attorney general that you were going to file this lawsuit. You were telling him, hey, we're going to file this. It's ridiculous.
The Justice Department filed the lawsuit before U.S. District Judge Reed O'Connor, a George W. Bush nominee in the Wichita Falls Division in Northern District of Texas, whose court has become a destination for conservative litigants seeking favorable outcomes. The groups Democracy Forward, the ACLU Foundation of Texas, and the National Immigration Law Center filed a motion on Tuesday on behalf of La Unión del Pueblo Entero. See, I think I did that good.
Spanish good job.
A union founded by Cesar Chavez, the Mexican-American Legal Defense and Educational Fund, had previously filed a motion to intervene in the case.
Yep, and the motion filed Tuesday argued that the sequence of events compels one conclusion. The United States and the Texas Attorney General colluded to predetermine the outcome of the case. The motion added, quote, the founders did not design our adversarial system for shadowboxing between co-parties. That's well put. The system demands opposition, argument, and deliberation, not consent decrees masquerading as litigation. Now, Skye Perryman, who we've had on the Daily Beans, the president and CEO of Democracy Forward, criticized Paxton for not defending the bipartisan Texas DREAM Act, bipartisan, which the legislature passed and Rick Perry signed into law more than 2 decades ago. She noted that the legislature had declined to repeal the law. That's how you repeal a law.
That's how you do it. Yeah. And Paxton recently announced that he is going to challenge U.S. Senator John Cornyn in the Republican primary next year, a GOP versus GOP battle between two men who have been sparring for years and vying for Donald Trump's attention, and not only his attention, but his admiration. Carl Tobias of the University of Richmond School of Law said the heads of Texas House and Senate should be concerned that Paxton's office declined to defend a state law. Quote, the whole American premise of settling a case is that you have people who have conflicting interests, and that's why they're in court to begin with. But, of course, we know for political reasons, they're probably not.
Mm-hmm. Yeah. Now, let's see. Sai Krishna Parkash of the University of Virginia School of Law, who has researched the duty of state attorneys general to defend laws in all 50 states, said more attorneys general are willing to say laws are unconstitutional. Quote, part of the reason why they're more willing to do that is a political reason, and they want to be a senator or a governor. Parkash said that across Republican and Democratic presidential administrations, there's been a tendency to settle when a litigant takes a position the administration supports. Administrations also want settlements that will bind the next president to policies their parties support.
Meanwhile, the Trump administration is suing more states over in-state tuition policies for undocumented students. The Justice Department sued Kentucky last week over its policy of giving in-state tuition to undocumented migrants. On Wednesday, the Justice Department sued the state of Minnesota over its law doing the same. In both instances, the Justice Department pointed to the outcome in the Texas case as justification.
Yeah. Now, what could this look like? This could mean Donald Trump could sue Missouri for when their voters elected to, be able to protect abortion care.
Now, doesn't this all so if they said they're using the Texas case as a justification, now, doesn't that apply to something that a blue state, has ruled against Donald Trump? And now they're saying, wait, this happened here. So they're using, as we mentioned in the article, that favorable district in Texas to get these rulings. But if they're using it as justification in that place, well, you know what? Let's use stuff to our favor.
Well, that's what I'm saying. Next time we have a Democrat in the White House, we should sue blue states for laws we don't like, right? What's good for the goose.
I'm with it.
That's what I'm looking for my next candidate for president. Somebody who's willing to do that. Somebody who's
willing
to
say, take the gloves off.
Somebody who's willing to say, oh, no more nationwide injunctions. Great. I'm just going to issue a bunch of executive orders. No more assault rifles.
Yep.
Go ahead and sue. Can't have a nationwide injunction. You got to do a class action now.
Sounds good.
Oh, we're going to protect the board. We're going to bring Roe back. Executive order. We're bringing back Roe. Hey, no book banning anywhere. Hey, we're going to repeal the Electoral College. Just whatever it is. Tell me what you're running on. Tell me what you're going to do with your executive order pen now that presidents are kings.
Yeah.
All right. Speaking of using Republican tactics against them, this story is from Politico. Gavin Newsom is taking a page right out of Donald Trump's media playbook. California governor accused Fox News of defamation in a lawsuit last Friday, alleging the network should fork over $787 million after Jesse Waters claimed Newsom lied about his phone call with Trump, who ordered National Guard troops to Los Angeles. Newsom's lawyers argue that Waters' program misleadingly edited a video of Trump to support the claim. Interesting. Misleading editing, something that Donald Trump sued ABC for, right? Or 60 Minutes.
Yeah. I think ABC settled. Yeah. It was the same thing.
That was for Stephanopoulos saying that there was a... Now, the Democratic likely presidential hopeful's request for damages is nearly identical to the $787.5 million sum that Fox News paid Dominion Systems in 2023 to settle another defamation case over election falsehoods. And it comes amid a spate of lawsuits from Trump against major media outlets and other companies that result in multi-million-dollar settlements.
Listen, I am here for that. I am so here for this. It goes on. If Fox News wants to lie to the American people on Donald Trump's behalf, it should face consequences, just like it did in the Dominion case. Newsom told this to Politico. Until Fox is willing to be truthful, I will keep fighting against their propaganda machine, end quote. Fox News put out a statement and it said Governor Newsom's transparent publicity stunt is frivolous and designed to chill free speech critical of him. We will defend this case vigorously and look forward to it being dismissed. Isn't that kind of what they said about the Dominion case?
Yeah.
Uh-oh.
Yeah, that's right. We're trying to chill Fox's free speech. That's what's going on. Public officials must clear an extremely high legal standard to prevail in defamation cases, as the U.S. Supreme Court established 6 decades ago in the New York Times v. Sullivan. But the lawsuit's filing marks a pointed escalation in Newsom's feud with the Republican president and his allies in the media. Newsom is suing in his personal capacity and has agreed to pay any possible fines or penalties from his campaign account, according to aides. I'm not sure if he can do that, but hey, way to go. Any proceeds from the case to Newsom would be disseminated to anti-Trump causes, according to Newsom. Newsom's suit echoes Trump's own lawsuits against major news networks like ABC, which agreed in December to pay Trump $15 million to settle a defamation case over Stephanopoulos' inaccurate claim. Actually, it was an accurate claim. It was accurate.
Yeah, it was.
That Trump was found civilly liable I guess he wasn't found civilly liable for rape.
Sexual assault or abuse or...
Right, but he did rape her. If he had just said you raped her, that would have been fine. But civilly liable, technically, no.
Yeah. So a copy of Newsom's complaint filed in this Delaware Superior Court in the same state where Fox News is incorporated claims he last spoke with Trump for approximately 16 minutes by phone on June 7th. One day before the president deployed 2,000 California National Guard troops over Newsom's objections to quell the protest in Los Angeles. Trump, however, told reporters on June 10th he had spoken with Newsom a day ago, implying a conversation took place the same day 700 U.S. Marines were deployed to Los Angeles. Newsom refuted Trump's claim in a post on X minutes later.
Now, that evening, Waters played an edited clip of Trump's remarks on air before asking, why would Newsom lie and claim Trump never called him? He simultaneously showed a screenshot of the president's call history obtained by Fox host John Roberts, showing Trump's last call with Newsom was June 7th, as the governor had claimed. Newsom's lawyers argue the incident meets the legal standard for defamation and potentially harmed the governor's standing with voters in future elections. Additionally, they claimed it violated California's unfair competition law, which outlaws deceptive and unfair business practices. Mark Bankston and another private lawyer representing Newsom, Michael Teeter, summarized their case in a 5-page letter to Fox on Friday, littered with biting insults of the network's credibility and sarcastic jabs at Trump's mental acuity. Quote, "It is perhaps unsurprising that a near octogenarian with a history of delusionary public statements and unhinged late-night social media screeds might confuse the dates." That's what the lawyer said. But Fox's decision to cover up for President Trump's error cannot be so easily dismissed.
This is great. This is great. The governor's legal team is no stranger to high-profile defamation cases. Bankston represented the parents of an elementary school student killed in 2012 Sandy Hook massacre in a defamation suit against conspiracy theorist Alex Jones. Bankston's team secured a verdict in 2022, ordering Jones to pay $49.3 million in total damages. So,
very interesting.
This is going to get good. I mean, it's I'm rooting for Newsom. No bias here, right?
No, yeah, we'll see what happens.
Yeah.
But it is an interesting, colorable argument that he was defamed. We'll see how it goes in pretrial motions if it makes it that far. All right, we got a couple more stories, but we have to take one last quick break. So everybody stick around. We'll be right back.
All right, everybody, welcome back. All right, now we have 2 more stories for you from the past week. The first one comes from The Times. The cheese man, Kenneth Chesebro, a lawyer who helped spearhead a brazen legal effort to use phony slate of pro-Trump electors to overturn the 2020 presidential election, was disbarred in New York on Thursday, cementing an indefinite ban issued last year. Great news. The decision by a New York State appellate court concluded a strange legal journey for a Harvard-educated lawyer who worked for former Vice President Al Gore during the 2000 presidential election recount in Florida and later evolved into a supporter of Donald Trump.
That's interesting that he worked on the Gore case in 2000, right? Now, in a 7-page opinion, the court cited a criminal racketeering case centered on the fake electors in Georgia, where in 2023, Mr. Chesebro, pled guilty. The New York court said Thursday that Mr. Chesebro's criminal conduct, conspiracy to commit filing false documents, is unquestionably serious, and that he had undercut the very notion of our constitutional democracy that he, as an attorney, swore an oath to uphold.
Yeah. Sorry, not sorry. All right.
So I found a Rudy story for you.
Yes, we love good Rudy news, but only when it's embarrassing to him. So this isn't really like
Rudy
good.
News,
This is bad Rudy news. But it's from CNN. Donald Trump announced his appointments to an advisory council inside the Department of Homeland Security on Tuesday, with a list that includes a right-wing news commentator, former lawmakers, Trump's former attorney, Rudy Giuliani, and a top former campaign advisor.
Oh, great. So Rudy Giuliani's in charge of our anti-terrorism stuff. Cool. The list includes right-wing political commentator Mark Levin, as well as Rudy, who helped lead efforts to try and overturn the 2020 election results and was later sued for defamation by 2 Georgia election workers. That's Ruby Freeman and Shay Moss, a lawsuit he lost before a jury in Washington, D.C. The appointments also include Corey Lewandowski, a Trump campaign leader in 2016, who is currently a chief advisor to Nome. Is that what the kids are calling it these days? Chief advisor
to Nome.
Other members of the council include South Carolina Governor Henry McMaster, who will chair the council, as well as other government officials, attorneys, security experts. They didn't put experts in quotes, but I'm going to. As well as the founder of Bikers for Trump.
Are those like stationary bikes or
Peloton
riders for Trump? Oh, God.
According to the Department of Homeland Security. So this is let's see, what is this called? This is an advisory council inside DHS. Okay. Huh.
So literally just
advisory council, advising what?
Is it a fluff position?
Yeah, like advising the best cigars to smoke
what are we doing here?
On the taxpayer dime. Like,
what are we doing here?
Department of Homeland Security. Honestly, that whole department just needs to go, man.
Go.
If you're not gonna, the only thing the Department of Homeland Security should be focused on is the number one terror threat to the United States, which is homegrown domestic violent extremism based on white supremacy.
They're Trump supporters, though.
If the entirety of the Department of Homeland Security isn't focused on the number one terror threat to the United States, there's no reason for it to exist.
At all. They have one. What did they say? You had one job.
Yeah.
You got one job. Yeah. And that is to keep us safe from, like Allison said, the number one threat to this nation. And it is homegrown domestic terrorism, usually by white males. Mm-hmm. Sorry to,
white
the
supremacists.
Ones that are, to white supremacists. Yeah.
I mean, this is basically like the 3%ers, the Boogaloo Boys, the Proud Boys, the Oath Keepers, those kind of domestic violent militias. And then like the Eamon Bundy, sovereign citizen, Branch Davidian type, like that neo-Nazi groups. Did you read? And, we didn't really cover it. We didn't really get to this story. We're going to cover it. We've covered it, I should say, on the Daily Beans, but that somebody in Coeur d'Alene set a fire to lure firefighters and then shot at them.
That's what I was going to ask you. I saw a headline that said he had ties to the anti-government, though. Is he one of those white extremists? Like, I just saw a couple of headlines. I didn't get to research it like I wanted to, but I saw early reports that said that.
I don't know. I had assumed as soon as it happened that it was some kind of sovereign citizen, Eamon Bundy, Branch Davidian type person. But, somebody that would have gone to the Capitol on January 6th if they had the means and motive.
Yeah.
But I don't know. I don't know what the motive is. Well, you know what? While we're sitting here.
But this is horrible. I mean, it's just horrible to think about just those first responders. And it just goes to show that they are showing up, doing their job, and just get taken out because of who they are. And it's really sad. And the family members and the community that's going to be shaken because of that is terrible. So.
Okay, so here it is. Here's the latest. A man shot firefighters battling a blaze in northern Idaho after they asked him to move his vehicle, killing 2 of them and wounding a third. The man had set a fire, and the firefighters who rushed to put out the blaze Sunday instead found themselves in an unexpected shootout. They took cover behind fire trucks, but 2 died and a third was wounded during a barrage of gunfire over several hours. It appears the man later killed himself. That's according to Kootenai County Sheriff Bob Norris. That's a breaking news update. So that seems like the latest on it. Now, I don't know that I would trust Bob Norris to put out a proper motive, nor would I trust Kash Patel's FBI to do so. But he is dead.
Yeah.
But so apparently that's the newest thing, is that the firefighters asked him to move his vehicle.
Okay, yeah, I didn't see that report, but hopefully we'll get some very clear explanations about this. But on another note, speaking about motives and unthinkable crimes and everything like that, how about Joe Biden showing up for that funeral and Kamala Harris was there? It just made me just smile with grace. It wasn't announced. He didn't give a big speech. He didn't show up, and he was just there to support, the supporter and comforter in chief. And Donald Trump couldn't even pick up the phone.
No, nor would he. I think he said he wasn't going to. He said he wasn't. Why would I call Tim Walz?
But just the pictures when Joe Biden, and like I said, these aren't Joe Biden posing for pictures. These are paparazzi-ish people catching pictures of one of the most compassionate presidents ever.
Yeah, just he's not running for anything, right? He's just
he's fighting for his life with his cancer.
Yeah,
So I mean, that gave me the feel goods inside seeing those pictures of Joe Biden.
First woman to lie in state. First dog.
The first dog too,
because their dog Gilbert
was shot too.
Gilbert was supposed to be a therapy dog for going through training for veterans with PTSD and first responders, but was too friendly. And so that's why the Hortmans adopted him and as a family pet, but then went on to continue the work of helping other dogs be trained for first responders and veterans with PTS. So that the whole story is just so painful, and it was heartening to see President Joe Biden there.
It definitely was. We miss you, Joe.
Vice President Kamala Harris. Yeah, I miss that. I miss that.
Yeah,
I do. Anyway, everybody, thank you so much for listening. Thanks to our new patrons. We really appreciate you. Again, we couldn't do this without you. We'll be letting you know about when the July Zoom happy hour is going to be. I'll see who I can't wrangle up to get to join us for that party. And do you have any final thoughts today, Harry?
I'm just thinking this is Wednesday. We're talking to you all. So unless you all are patrons, we won't talk to you before the 4th of July. So happy 4th. No silly firework incidents. And drink plenty of cold beverages.
Keep all your fingers, please.
Yes, please.
All right. Thank you so much, everybody. We will see you next week for the public episode, and patrons this week for the bonus. And really, again, appreciate you listening so very much. Thank you. I'm Allison Gill.
Harry Dunn. Thanks, y'all.
Cleanup on Aisle 45 is written, researched, and produced by Allison Gill, with editing by Molly Hockey. Our art and logo design are by Joelle Reeder and Moxie Design Studios, and our music is composed and performed by Adam Orr. Cleanup on Aisle 45 is a proud member of the MSW Media Network, a collection of creator-owned podcasts dedicated to news, politics, and justice. For more information, visit mswmedia.com. MSW Media.